Okay. Thank you. Good morning. My name is Hang Lei To, the chair of the Professional Fiduciaries Bureau Advisory Committee. I'm calling this meeting to order at 10:01 a.m. This meeting is being held on Thursday, March 29, 2018 at the Department of Consumer Affairs located at 1747 North Market Boulevard, Sacramento, California 95834, and has two teleconference locations at Elderwell located at 6345 Balboa Boulevard, Building 1, number 114, in Encino, California 91316, and at the Jordan Goldstein Fiduciary Services located at 5 3rd Street, Suite 1132 in San Francisco, California 94103. All three meeting locations are open to the public and accessible according to the American Disabilities Act standards. Now we are at item number 2. At this time, I would like to ask Angela to call roll to establish a quorum.
Hang Lee Do,
Present?
Kathleen Thompson,
Present.
Dawn Nicole,
Present.
Jenny Chacon, Barbara DeVries, Eileen Federizo, King G.
Present.
Thank you. With 6 members present, we do have a quorum to start the meeting.
Thank you, Angela. Item number 3, I would like to ask the committee members and Bureau staff to introduce themselves. I'm Hang Lei To, the Financial Director of the San Francisco Labor Council.
King G, committee member, senior advocate.
Donna Kell, Fiduciary, California.
Kathleen Thompson, Supervising Court Investigator for Solano County.
Jordan Goldstein, professional fiduciary.
Barbara?
Yes, Barbara DeVries, professional fiduciary, mainly San Francisco, doing it for 27 years.
Eileen?
Eileen Federizo, geriatric social worker and professional fiduciary, doing it for over 20 years.
Okay, thank you. Is there anyone in the audience that would like to introduce themselves?
I guess Stanley, member of public.
Thank you. Now we are at item number 4. I would like to invite the Department of Consumer Affairs executive staff to present their update. Good morning.
Good morning, everyone. Chairwoman Doe, Vice Chair Thompson, Chief May, members. Thank you for allowing me an opportunity to provide some brief remarks and updates from the Department of Consumer Affairs. My name is Karen Nelson, Assistant Deputy Director with Board and Bureau Services. Been with the department about 5 months now and have had the great pleasure of working with a good amount of our boards and bureaus and learning about the very important work that you all do to protect California's consumers. So I wanted to first start off with some staffing updates. We welcomed a new Deputy Director of Legislative Affairs on March 12th. His name is Dennis Cuevas Romero. Before coming to DCA, Cuevas Romero was Government Relations Director at the American Heart Association, American Stroke Association in Sacramento since 2016. He was a legislative associate at the Hernandez Strategy Group from 2013 to 2016 and a postgraduate law clerk at the Sacramento Regional Fair Housing Commission in 2012. I hope that you will all welcome us in having Mr. Cuevas Romero with the department. A couple of calendar updates. Earlier this month in March, the department's Future Leadership Development Program graduated its first inaugural cohort, and 12 individuals completed the 8-month leadership program, participating in various leadership development exercises working on some team projects that could positively impact the department, developing new working relationships, and meeting with several of our executive officers who are sharing career advice with our future leaders in the department. Next month, April 30th, the department will hold its second Directors Quarterly meeting with its board executive officers and bureau chiefs. And this is a platform for all of our leadership, executive officers, as well as chiefs to talk with the director, have a dialogue, and ensure that director is available to you and hear important issues facing its boards and bureaus. And a couple of new items that the department has. Solid is now offering additional training and team building specifically geared to board members, committee members, executive level board and bureau staff. It's the board member and executive boot camp. And these courses are designed to improve interaction and facilitate cohesiveness within groups, provide a safe environment for communication, and build positive relationships by providing several unique tools and techniques. And Solid can customize these trainings if you all are interested. And some of the topics include conflict styles, true colors, going from good to great, leadership styles, and working with difficult people. And so if you are interested, please do feel free to contact our Solid team to schedule that training. And lastly, our licensing and enforcement work groups. As you all know, this is part of our department's strategic plan. And we are launching a licensing and enforcement work group to share best practices and really share some knowledge with our boards and bureaus. So on April 10th, in a couple of weeks, we will convene these work groups and start that process and the dialogue and strengthening processes with licensing and enforcement. And that's all I had for today. And as always, if the department can be of service to you, please let us know. And thank you.
Thank you, Karen.
Yep.
Any comment from the committee members? Any public comment? Thank you. Item number 5. Rebecca, please read the Bureau's mission statement.
Thank you. So our mission statement is to protect consumers through licensing, education, and enforcement by ensuring the competency and ethical standards of professional fiduciaries.
Any comment from the committee members? Any public comment? Thank you, Rebecca. Item number 6. Are there any suggested edits from the committee members about the minutes?
This is Eileen Federico. I move that we approve the minutes.
Is there a second to the motion?
Second.
Barton DeVries seconds the motion to approve the minutes.
Thank you. Any discussions from the committee members? Any public comment? So Angela, please do a vote by roll call.
Okay, so this will be a vote to approve the minutes as written to be posted on the website as final minutes. Barbara DeVries,
Approve.
Eileen Federico, Jenny Chacon is absent. King G,
Approve.
Donna Kell,
Approved.
Kathleen Thompson,
Approve.
Hang Lito.
Approve.
With 6 votes to approve, the minutes will be posted as written.
Thank you, Angela. Item number 7. I would like to invite the Department of Consumer Affairs Budget Office to present the budget update.
Good morning. My name is Nicole Dragoo from DCA Budget Office. Thank you for having me this morning. If you want to take a look at page 7, we've included the fiduciary fund condition. This was introduced in the 2018-19 governor's budget on January 10th. It showcases the 2016-17 actual numbers, and it's broken out by the beginning balance, which carries over from the prior fiscal year, which was 15-16. It shows the Bureau's actual revenues, the actual expenditures, the fund balance, and the months in reserve. Moving forward to the current year, the fund beginning balance rolls over from the 16-17 fund balance, the projected revenues, and expenditures. The number that you see there is $538,000, which is the Bureau's entire appropriation, and we always assume that the Bureau will spend its entire appropriation. However, when this fiscal year ends, you will see these numbers change. Months in reserve mean if the Bureau ceases to bring in any further revenue that it can operate that many months, we ask that the program stay above 3 months in reserve, so at 4.2 months, and moving up in budget year 18-19, it's looking great. Are there any questions on the fund condition?
What is other regulatory fees? It's 4129200 under revenues.
That's a very good question. I would actually need to go back and look at the detail to see what falls in for this Bureau. It can be different for each program. I will go ahead and research that and let Rebecca know. You're welcome. Any other questions?
Yes, this is King G. Oh, go ahead, I'm sorry.
Anybody you know here.
Oh, okay.
Thank you, Jenny.
Yes, this is King G, and I have a question regarding the allotment for the Attorney General, the 66,000.
Oh, are we looking at the projections?
Yes.
Okay,
It looks like we're not going to spend all that this year,
Okay.
and will the surplus, can that be reallocated?
So with the surplus, that actually will feed the months in reserve, the fund. Anything that's not spent will go into next year's fund, but it won't add to the appropriation per se. This is a bottom line budget, which basically means that each line item, if one line item is expended or overexpended or underexpended, it's not the end of the world, because as long as the Bureau is not expending over its entire budget, then everything is safe. If the Bureau wanted to look into adjusting its attorney generals, then that's something that can be done through an augmentation, which we have the opportunity to do that several times per year, or through a budget change proposal.
Well, the reason I'm asking is we have some challenges in the Bureau in terms of reaching out to the communities throughout the state as far as travel costs, and I was just curious whether some of those funds might be reallocated to that.
We can
purpose.
actually shift line item appropriations, which is not, this is just for display. I can chat with Rebecca and we can talk about shifting the line items so the travel line item does look healthier if you would like the display to be changed. Absolutely.
Okay, thank you.
You're welcome. Any other questions? Okay, I'll give a brief overview on the expenditure projections, which are page 8, I believe. They're broken out into personnel services and operating expenses and equipment. These are current as of FM8, which is February, fiscal month 8. These are point-in-time numbers from mid-March, so everything looks really good here. The Bureau is expected to revert about $10,000, which will carry over for the next fiscal year. Nothing looks out of ordinary or of concern. However, does anyone have any questions?
My name is Hang Leito, and I have questions about the personnel. it seems like we have a deficit 20, even though the budget looked very good, very healthy, that we have $10,000 surplus. But the item on the total personnel services is 23,000 deficit. So just question, like wondering if, why we are under that, but, under the budget.
Oh, absolutely, and I do know, I do realize it may look concerning. However, the Bureau is fully staffed right now at the 3 personnel. The budget allotment for those has not been, the line items have not been adjusted, and as I was telling Mr. G, we can go ahead and talk about realigning them so perhaps a more accurate picture is painted for display.
Thank you.
You're welcome. Any other questions?
Any comment from the committee members? Any public comment? No? Thank you, Nicole.
Thank you.
Okay. Item number 8, I would like to invite the Department of Consumer Affairs Legislative and Regulatory Review Office to present the legislative update.
All right. Good morning, everybody.
Good morning.
I'll try and speak loudly into the mic. I can be a little bit of a mumbler. My name is Alex Millington. I'm an analyst with the newly renamed Division of Legislative Affairs. So it's once again changed its name. It's now the Division of Legislative Affairs. It's a pleasure to come down and deliver an update to you folks. I know it's been a little while. What I'm going to talk about, I'll split up into, I think, 4 main sections. First, we'll talk about some of the approaching deadlines in the legislature. Then we'll talk about legislation related to the Bureau, legislation related to the department, and then there was, at the past meeting, a point of clarification requested on AB 1380, and I'll go into a little bit more detail on the response to that question. So first, legislative deadlines here in, well, now spring of 2018. I included February 16th in there, even though it's in the past. It's a particularly important deadline. February 16th was the last day for new bills to be introduced. March 22nd, which is this week, is the legislature's spring recess. So the legislature is currently in recess and will reconvene on April 2nd. On April 27th, that's the last day for policy committees in the House of Origin to hear and report to fiscal committees bills in the first house. May 11th is the last day for policy committees to hear and report to the floor for vote bills in the first house. May 18th is the last day for policy committees to meet prior to June 4th. May 25th is the last day for fiscal committees to hear and report to the floor those fiscal bills that are in the first house. June 1st is the last day for each House of Origin to pass bills introduced in that house. And June 15th is the deadline for the budget bill to be passed. That deadline is at midnight. Any questions about the legislative deadlines? All right, next, there's legislation related to the Bureau. First, AB 1779. This bill would prohibit a mental health provider from engaging in sexual orientation change efforts with a patient regardless of that patient's age, including those individuals under a conservatorship or guardianship. My understanding is that this type of practice is referred to as conversion therapy. So this bill would prohibit that practice, including for individuals under a conservatorship or guardianship. This bill was introduced in early January of this year and has been referred to the Assembly Committee on Business and Professions, but has not yet been scheduled for a hearing. Next is AB 3144. That is this Bureau's sunset bill. As currently written, the bill would extend the sunset date of the Professional Fiduciaries Bureau to January 1st, 2023. And there was a joint Senate and Assembly committee which heard testimony from Ms. May on March 5th. Right now, all the sunset bill contains is an extension of the Bureau's authorization to 2023. It may be amended before it passes to include other items. I haven't seen any amendments on it yet. It has been referred back to the Assembly Committee on Business and Professions, but hasn't been scheduled for a further hearing. The Joint Committee did submit some follow-up questions requesting clarification from the Bureau. Our office worked with Ms. May to provide the committee with some follow-up answers. The questions from the committee were pretty much consistent with what was in the Bureau's published Sunset Report. There wasn't anything outside the scope of what was discussed at the March 5th meeting or what was contained in the Bureau's Sunset Report. Finally, here we have SB 909, which is called the Uniform Trust Decanting Act. I am going to read this one, the description of this one, because it's a little bit more technical. This bill would allow a fiduciary of an irrevocable trust to distribute the property of a first trust to one or more second trusts, or to modify the first trust without the consent of the beneficiaries or approval of the court, subject to certain exceptions. This bill would require notification of affected parties prior to the decanting and would create court authority to allow decanting on application by a fiduciary, a beneficiary, or other specified parties. This bill was introduced in mid-January of 2018 and has been referred to the Senate Judiciary Committee, but has not yet been scheduled for a hearing. Are there any follow-up questions on those bills related to the Bureau?
Hi, this is Eileen Federizo.
Sure.
Regarding AB 1779, does it mention anything about the type of guardianship or conservatorship? For example, what if somebody's under a limited conservatorship versus a general conservatorship? When I say limited, there are situations where we're the conservator, but really our powers are very limited. So I wanted to understand that.
I'm not the analyst who's assigned to that bill, but certainly I can talk to that individual and follow back up with you folks with an answer to that question. And just to make sure I'm understanding the question correctly, you'd like to know whether or not this bill has anything to say about the type of guardianship, including limited guardianships, as to whether or not folks under those limited guardianships would be affected by this bill.
Exactly.
Okay. Thank you very much for that question. Are there any other questions? All right, we'll move on to legislation related to the Department of Consumer Affairs. All of these bills that are in here are bills that have been discussed at prior meetings. They are all 2-year bills, so there isn't anything that's new in this list. So I'm not going to describe each one of these things in detail, just for the sake of brevity. But if you take a look at all the items here, you'll see that all of them have an indication in their March 2018 status that they failed to meet a January deadline. That means that they are effectively dead and that no further action can be taken on those bills. The exception to that is, let me find it here, AB 827, which of course goes across 2 pages. But at the top of page number 3, the March 2018 status indicates that it remains in the second house. It means that further action still could be taken on this bill. I haven't heard anything directly indicating that further action is going to be taken, but it still remains short of its final deadline, so it is still technically alive. Again, everything else is pretty much dead. Are there any questions about those bills related to the department? All right, lastly, I'll talk a little bit about AB 1380. As I'm sure everybody remembers, AB 1380 would require regional centers to develop a process by which vendor contracts are reviewed every 2 years, and would require those reviews to be documented in the regional center's files. Additionally, this bill would require an employer to submit the fingerprints of prospective in-home respite workers to the Department of Justice for background checks, and would prohibit employment as an in-home respite provider if the applicant has specified convictions. This bill would also require the Department of Development Services to conduct a review of in-home respite provider rates and report those results to the legislature. Now, first off, this bill does remain a 2-year bill, so it has not failed any deadlines, and it hasn't failed a final deadline yet. It's still technically alive. There are no further amendments that have been made up to this point in 2018, although there may be some in the future. At the November 27 Advisory Committee meeting, there was a request to give a little bit of additional information about what kind of specified convictions might prohibit an individual from being employed as an in-home respite provider. The answer, the answer to that is fairly complicated. Briefly, this bill would place restrictions on employment eligibility for individuals with sex crimes histories, attempted child abuse, attempted child neglect or endangerment, attempted elder or dependent adult abuse, theft, robbery, burglary, or other felonies. This bill would also place a bar against individuals with convictions for fraud against a government health care or supportive services program, as well as actual child neglect or endangerment, and actual elder or dependent adult abuse. And this bill would also add a section to the Welfare and Institutions Code specifying that in-home respite worker employees must submit their fingerprints to the Department of Justice. Now, below here, I've included a much more detailed breakdown of exactly the criteria and the different outcomes that can occur for individuals who do have convictions. So, there are 3 separate scenarios. One, for certain convictions, an employer has the discretion to deny employment. So they may or may not hire this individual. And those convictions are listed below. Under Section 2 there are convictions which completely bar an individual from being hired as an in-home respite worker, and those convictions are also listed below. And then finally, there's a narrow third scenario in which an individual can be hired but cannot be paid for a period of 10 years following certain convictions. And those are also listed below. And then lastly, there is a sort of technical wrinkle where an individual who does have convictions can nonetheless be employed if they obtain a certificate of rehabilitation, and as well, an individual wishing to hire an in-home respite worker may also seek a waiver of the exclusions based on criminal history. Are there any questions about AB 1380? All right, folks. I don't hear any questions. It's been a pleasure to come down here and appreciate your time. Thank you very much.
Madam Chair, what about public comments?
Oh, I'm sorry. Thank you for. Any comment from the committee members? Any public comment?
Hi, committee members. My name is Gerry Desmond. I'm the legislative advocate for the PFAC, the Professional Fiduciary Association in California. And I just felt that it would be nice to come up and discuss the position of PFAC on AB 3144 and the continuation of the Bureau. I think most of you know PFAC again has a position in support of the extension of the Bureau. We would, of course, prefer that it be made permanent and that the extension be permanent, make the Bureau permanent, but we know the political reality that an extension of 4 years is probably doable, and we support the extension. And so we have testified at the Sunset Review hearing in that regard and continue to advocate for that in the Capitol. Thank you.
Thank you, Gerry. Thank you, Gerry. Thank you, Alex. Now we are at item number 9. Rebecca, please present the Bureau updates.
Thank you. So we'll start with the statistics regarding licensing and enforcement matters. There was a request at our last meeting in November to provide a comparison of licensing and enforcement matters for the last two fiscal years. So we've got handouts in the packets that show the data comparisons as of February 28th, 2017 and February 28th, 2018. If you want to look along with me, you can see that the Bureau has issued the same number of licenses this time as last year, but there was an increase in active licensees of approximately 3%. The Bureau is, of course, always trying to increase our outreach opportunities to see those numbers rise. As for enforcement, the number of complaints that we've received has increased by approximately 35% over the last year. But the good news is that the Bureau staff was able to decrease the number of pending complaints and the average days to close a complaint pretty significantly. And we've also issued about 7 citations this year. Any questions? Okay, I'll move on. Oh.
I have a question. Can you talk a little bit about the nature of the increase? Is it a result of increased visibility of the Bureau, or are there particular trends in the complaints that we practitioners should be aware of?
I'd like to accredit it to more outreach. I think we've really been trying to increase the visibility of the Bureau by going out, explaining what it is that we do at senior fairs and the like. So I think that that's probably, I'll credit it to that. I don't know if there's any particular trends in the complaints. Most of the complaints we receive do not ultimately end up in any sort of enforcement or disciplinary action. They're usually like someone's dissatisfied with the services that they received, but it doesn't necessarily turn into any kind of violation.
This is King G. I have a question. I'd like to commend the staff for reducing the number, the average days to close cases. Looks like it's pretty significant. Could you share with us what was the rationale, or what was the efficiency causing that reduction?
I think it's probably, well, we do have a good method of making sure that we respond quickly to complainants and that our complaints are assigned quickly. I would think that likely the reduction is in the complexity of the complaints, frankly. So maybe that's luck. But we do have a hardworking staff, and we go over the enforcement. We meet twice a month generally to make sure that we're looking at some of our more aging cases and seeing what we can do there. But yeah, that's what I would say.
Hi, this is Eileen Federico. I wanted to find out for the active licenses, 3% is a great increase. I wanted to, do we have like a target goal every year of how much or what percent we want to increase by?
No. There's no specific target. Moving upward versus moving downward is certainly the goal. Okay, so I'll move on to the next item, our Attorney General cases. So there was also a request at the last meeting to provide information on the types of cases that we send to the AG's office. Cases that go to the AG's office typically are where we have cited a licensee and he or she has asked for a formal appeal of their citation. Also, if we find that a licensee has violated the law in a more egregious fashion that deserves possibly more discipline than a standard citation, we would refer those to the AG's office as well. Some of the recent cases that we've referred to them, we had a licensee that failed to notify the Bureau that she had been removed by the court for breach of her fiduciary duties, and a failure to provide records to the Bureau, even though we had requested them. Another one we had sent recently was a licensee who made false statements in petitions to the probate court in support of their request for fees, and that licensee was surcharged $125,000 for committing acts of fraud and dishonesty. And another more interesting case we had was where a licensee sold a client's car without the client's knowledge and forged the client's name to the DMV. So those are the kind of enforcement cases that would go directly to the AG's office. Any questions? Okay, outreach events. And so in your packet, there are some outreach events, but we've added a couple since the handouts went out. In January, Angie and I attended a SACFAST, Sacramento Financial Abuse Specialist Team event with Adult Protective Services here in Sacramento. In February, I went to a senior resource fair in Dixon. A few weeks ago, in March, Angie and I attended a senior and veteran fraud prevention fair in Reading. That was held by the Shasta County District Attorney's Office. We also have some upcoming events. We will be attending for the second year in a row. The Mexican Consulate in Sacramento has a financial education fair, so we'll have a table there. And that's next month. Also, next month, California Financial Literacy Month Resource Fair. That's held by the Department of DBO, and I'm blanking on the acronym. Thank you, Department of Business Oversight. So they'll have a fair at the state capitol. We'll have a table there. There is also in May, Angie is kindly offered to go up to Wairika for a Senior Services and Fraud Prevention Fair. Also in May, we'll be attending a Senior Health and Fraud Awareness Fair in Citrus Heights. At the end of May and early June, Angie and I will be going to PFAC's annual conference in Riverside. And then again in June, heading back up to Reading for a resource fair on the Sundial Bridge. So that should be interesting. Any questions? All right, so Sunset Review. I am really pleased to announce that the worst part is past us now. Our Sunset Review hearing was on March 5th, and the Bureau's sunset was recommended for a 4-year extension, which was really great. That's typically the most number of years that an extension would be granted. The bill is AB 3144. I anticipate that there'll probably be some amendments to that bill the next time we meet, so I'd like for there to be, when we discuss our future agenda items, I'd like to have a more robust conversation about that bill at that time. I think we'll have more to talk about then. I know PFAC has some proposals, our Bureau has some proposals. Any questions? Okay, so I'll provide an update from the status of our occupational analysis. This is information that I received from OPES. The occupational analysis has been completed, and staff are currently writing up the report, and this should hopefully be released in early May. At the last workshop, in addition to finishing the analysis, OPES staff conducted a linkage study, which is basically linking the tasks and knowledge collected during the analysis with the core competencies of the examination that's provided by the National Guardianship Association. And the good thing is they won't need to schedule another workshop for this project. And finally, OPES staff are currently in communications with the Center for Guardianship Certification to do a review of the psychometric quality of the California Professional Fiduciary exam. Assuming that the non-disclosure agreement is signed and OPES receives the information requested, the review should be released by the end of May 2018. Any questions? Okay. And finally, an update on the status of our strategic plan. So Bureau staff met with DCA's solid team on January 4th, 2018 to review the survey answers provided by our committee members, licensees, and other stakeholders. And with these results, we drafted a plan with objectives to be carried out over the next 4 years. The plan was recently approved by the Director of the Department of Consumer Affairs, and we've scheduled an action planning meeting on April 25th to plan out how each objective will be accomplished. And the action plan will have tasks, list who's responsible for each task, provide deadlines, and create success measures for each objective. And the plan itself is now being formatted for publication, so that should be ready in the next couple of weeks. Any questions?
This is Jordan Goldstein in San Francisco. Can you go back just a step or two to the mention of the psychometric nature of the fiduciary exam? Is that what you said? I'm pretty sure I understand that.
I barely understand it myself. This is all, frankly, above my pay grade. I wish Tracy Montez were here today because she is the psychometrician that knows this stuff inside and out. As I understand it, it would be a discussion to see if we can make changes to the examination with the examination provider, which is NGA.
Okay. Well, you can post it.
Yeah.
You know what?
Yeah, maybe another future agenda item could have OPES come and discuss it with us. I think they'll do a much better job of explaining it than I can.
Thank you.
Thank you. So any questions? Okay.
Any comment from the committee members?
Okay, so this is Eileen, clarification on the strategic plan. It's gonna be available in 2 weeks, but are we gonna discuss it at our next meeting? Or are we gonna get more information at our next meeting?
Yes, we can definitely provide additional information at our next meeting. So the strategic plan, the plan itself is just about ready to be published. And then we can go over the action items that at our next action. We're having a planning date on April 25th with Bureau staff and Solid. And we can, we can report again about that at our next meeting.
Thank you.
Thank you.
Any public comment? Thank you, Rebecca. Item number 10. Rebecca, please present the status of proposed rulemakings.
So the Bureau has completed the rulemaking file and it is now with the Department of Consumer Affairs in its internal review process. And we will update the committee once the file is submitted to the Office of Administrative Law.
Any comment from the committee members? Any public comment? Thank you, Rebecca. Item number 11. Rebecca, please start discussions on the draft language for the client notification proposed regulations.
Thank you. I'm happy to discuss our favorite proposed regulation. So the staff has submitted draft language, which was reviewed by our legal counsel. Thank you, Fred. And a copy of the proposed language is in your material packet, and hopefully you've had an opportunity to review the language. Do any of the committee members have comments or suggestions on the proposed language? Anyone?
Would you, this is Gordon Goldstein again. Would you please read the new proposed rule? I'm afraid I didn't print out the entire package of the agenda.
Did you say you want us to read the whole regulation? The whole language?
This is the regulation about our informing clients who governs the fiduciary profession, is that right?
Yes.
Correct.
And how long is it?
It's 2 pages.
Oh, well, no, please don't. Is it much different from before? We had gotten into kind of an elaboration of the requirements, and it went on to say that you had to say that your license was in good standing and so forth. So I wonder if it's been trimmed back a little bit just to reflect the legislative intent that the fiduciaries are responsible to inform our stakeholders who regulates fiduciaries, or does it go beyond that?
Let's have our legal counsel maybe go over the most salient points of the changes to the proposed reg. Fred?
All right. So, well, number one, I'm coming new on board here, so I was informed as to what happened to the previous reg package, and I got a chance to take a look why OAL disapproved it. And the main problems I saw in the old regulation was that I guess there was some clarity problems with the language, and there was some sort of problem with necessity on like certain key points. Now, the new language really clears up some of the clarity issues that were addressed by OAL, and also I think one of the focus on this new language is instead of trying to aggrandize the definition of a client or what a client is, it basically focuses on when services is deemed complete to the client for the notification. And I think if you take a look at, I think subsection D of the new language, it makes it very clear as to what is considered to be completed service. And also, there were also a couple issues with procedural problems with, according to OAL. So that's something that obviously we'll pay attention to when this goes forward for the rulemaking process.
Hi, this is Irene. Clarification. So on C, if the licensee maintains a website, you said, that posts that we are licensed and under the department, et cetera, that satisfies this notification? Is that what you just said?
No, I did not say that.
Oh,
No, I think the intended language is that if you have a website, you can put it on there, but that does not release you of the necessity to comply with subsection A.
Again, Jordan Goldstein, is on the Bureau's website under laws and regs, is there text of this proposal that I can look at while we're meeting?
To my knowledge, no, it's not on the material meeting.
Oh,
Yeah, it
yes,
is.
the
Yeah.
materials.
If you take a look at the meeting materials on the Bureau's website, you should be able to see a copy of this language.
It's right at the end. It's right at the end of the materials.
Okay, calling it up. Is it after the minutes of the last meeting?
It's all the way at the end.
Okay.
okay. So let me see if I understand this. Sorry, this is Irene Federico. So I'm the conservator, for example, for an elderly client who has severe dementia. So what I have to do is send them a letter notifying them of doing the notification, and then I just file that away into my file for 3 years. Is that correct?
If you take a look at subsection D, it tells you when the service is deemed completed. Now, subsection A tells you how you can serve the notice, but section D tells you in certain situations when it's deemed completed, the service that is. And also, if you maintain a website, subsection C would apply to you. And also, if you have a business, I think there's also a additional requirement on subsection B, which is at your place of business, you're supposed to put a notice there as well.
Okay, well, I guess the reason why I'm bringing up this my question is because it doesn't necessarily make sense for me to notice, but it's okay. I guess the purpose is to protect the public and the client, even if they don't understand it. Is that correct?
Right. I think that the intent of the law is to, is to provide notice to the clients that the fiduciary is a licensee. And that's why in subsection D, there are, the notice can be provided to other people, in certain situations. And that we deem completed to be served to the client.
Goldstein, once again?
Yeah.
I'm sorry, this is Jordan. As I read the initial legislative language that promulgated this rule, it did not, it wasn't for the purpose of informing people that our licenses were in place. It was, as I recall, for the purpose of informing people who regulate fiduciaries. And those are quite different. And I just want to be sure that we're not expanding the charge of the regulation beyond the legislative intent as specified in the language of the actual law. The whole question about how you do the notice is, the charge of the regulation is to tell us how to do that. But as I understood it, what we were supposed to be doing was telling people that we work with who regulates fiduciaries. Now, am I incorrect? Does in fact the requirement of the law include telling people that our licenses are in good standing? Just a point of clarification.
Okay, that's noted. If you give me a minute, I'm going to take a look at that right now, okay?
Thank you.
I have a question also. In subsection D, number 2, when we're talking about it's provided to the settlor and the beneficiary of the trust prior to appointment of the trustee, are we talking within the drafting of the trust where many times fiduciaries don't know that they've been appointed to a trust, or when the trustee, the successor trustee, is actually acting?
The question is, does subsection D2 require notification when the fiduciary does not know whether they're part of a trust yet?
Correct, it happens quite a lot. We
Okay.
often do not know when we're appointed. Somebody drafts with their attorney their estate plan. They name a trustee, a licensed fiduciary. We may not know for 20 years.
That you are a fiduciary of the trust?
Correct. It's not a requirement. That's a personal thing between the person who's drafting and the estate, the settlors.
So then do you have a fiduciary-client relationship until you know?
No.
So you could have so if I understand this correctly, you could have a fiduciary-client relationship without you knowing that you're...
Correct. It happens all the time.
I think...
This is Eileen Federico. Maybe what, the way I understand it though, is that even if we do get named on the trust, until we actually are notified and we say we accept the trusteeship, or we act, that's the terminology. Once we say, okay, we are going to act, that's when the fiduciary relationship technically starts.
Okay. All right, then that makes more sense. I mean, I can maybe add clarifying language.
Just a little bit clearer, yeah, I think, because you may not know. And then the settlor, as they're going through life, let's say every 5 years, has the right to change the trustee. So you may not ever know until you're acted upon, called upon.
Right. But okay. All right. I think I'll go back with staff and then we can take a look at that.
Thank you. This is the kind of feedback that we appreciate.
Madam Chair, if you don't mind, could we maybe take a 10-minute break so that I can go in and take a look at the to address the question that was previously asked about whether this exceeds the scope of the law.
Okay. So, committee members, can we take a 10 minutes break? Okay, thank you.
Okay, go ahead, Amy.
Eileen, are you still there?
I'm here.
Barbara, are you still there? Barbara, Jenny, are you still there?
We're here. Yeah, San Francisco's here.
Okay, awesome. We got a full house now. Okay. Okay, Fred, so please continue.
Okay, so to address the question as to whether this regulation exceeds the scope of Business Professions Code 138, I found the code section and I'd like to read it. Every board in the department, as defined in Section 22, shall initiate the process of adopting regulations on or before June 30th, 1999, to require its licentiates, as defined in Section 23.8, to provide notice to their clients or customers that the practitioner is licensed by the state. A board shall be exempt from the requirement to adopt regulations pursuant to this section if the board has in place in statute or regulation a requirement that provides for consumer notice of a practitioner's status as a licensee of the state. So in essence, this section says that boards and departments, boards in DC, including bureaus, are required to requiring to have a regulation that would require its licensees to provide notification to their clients that they are licensed by the state. So, from reading of this section, I don't believe that this regulation exceeds the scope of this statutory section.
Thank you very much. My misunderstanding was that the difference between informing people that your license was in good standing versus informing people about who the licensor is. And I thought it was intended to inform clients who licenses fiduciaries. Because, of course, in our practices, in any court supervised case, we have to state on an ongoing basis our licenses are in good standing. So that part of informing clients is taken care of by court pleadings. But it was my understanding, and I evidently you're saying that I was incorrect, that the regulation proposed was to merely, like the ombudsman has to put a poster up in a facility that if you have a complaint, you contact the ombudsman. I thought this was more along those lines, that just telling people there is a bureau, it licenses fiduciaries, and obviously here's the contact information if you have any issues. So you're clarifying for me that I had misunderstood. Is that correct?
In essence, this regulation and also the statutory section merely requires that the licensee provides, so the client knows that, hey, whoever's working on this is licensed by the state. That's really the bare essence of it. As far as the status of the license is concerned, that the statute has not addressed that. And I need to do some further research to see if the Bureau wants to add the status on the regulation. I would need to take a look at this a little further to see if that exceeds the scope of the statutory authority.
Thank you very much for hearing me out. I appreciate that.
Of course.
I have one question. When a petition is filed for, when a petition is filed for conservatorship or guardianship, it normally lists the private fiduciary and information about that private fiduciary, and then it's provided to certain parties that are listed in the petition. Does that meet the written noticing requirement under D?
If the notification were to go to these other parties?
Yes, there's a list of people who have to be noticed in those petitions.
Correct.
Is it? And
I think, Federica,
okay.
when we become a conservator or a guardian, or even a court-monitored trust, trustee, there's a notice list. It's a list of all the relatives. And so basically they get notified of our license and the bureau, et cetera, and who licenses us. I think that's what they're trying to say.
Right, but let me just ask the rationale. I guess that's the legal requirement, right? That these people are supposed to be notified. But again, I'm really new to this field, so I'm not quite understanding, like the reason behind that requirement. Is it more of a, hey, because this person is, is a conservatee and is not able to make their own legal decisions, and that's why these people on the list need to be notified so that they can make the decisions for them, or?
That's, well,
They get
it's
notified
transparency.
because in case somebody wants to protest or,
Petition.
want to be heard, then they get notified.
Right, okay.
And it's for transparency in the proceedings to let the family know that there is this proceeding, that there is an allegation that this person is incapacitated, and that this individual is petitioning to conserve them. And
Okay.
so there are, it's usually relatives to the second degree are required to be noticed
And
Okay.
then
And that's in the probate code.
in the probate code,
correct,
right?
and the fiduciary has to complete a confidential screening form, putting their license, all of that. That is kept confidential, but the relatives and interested parties are all noticed per the court requirement.
Okay, I can see what the rationale is. Okay, now the intent. I mean, from what I've researched and seen so far, the intent was really a notification to the client, just as if, like, for example, doctor to patient. I mean, at least from my understanding is the statute was not intended to require the doctor to also send out notices to to the patient's family members as well. Now, I think we're dealing with a obviously different situation with fiduciaries because we're talking about individuals who may not be, who may not be of sound mind or may not be able to make their own decisions. So, what if? Let me do some more research on this. And obviously, this is just draft language. It's no by any means of the word final or anything like that. So, we can certainly go back and do some more research and look at that, whether to see if this adding on this list of individuals on there, whether that's we can do that or not. I can research on that.
Yeah, this is Eileen Federizo. So I had a couple of other questions. For section D1, what is a natural person?
Anyone who's not a corporation or LLC. So a natural person is a human being.
Okay. And then also on A2, the email that's sent to a client to notify them, are they supposed to confirm the receipt of the email? Or just sending the email is sufficient?
I think sending the email is sufficient because the email would contain the date and to whom it was sent and the address of the recipient. And that's why the regulation is asking that the licensee maintain a copy of that sent email. Because that sent email in itself has the date and time of sending it.
Okay. And for section A, what is the significance of the 3 years? And is stating retaining the proof is an e-file document acceptable?
For what? For the notice?
I think it says on A that somebody has, hold on. Oh, I was thinking when somebody has to sign, by the parties, so a scanned version is fine, I'm assuming.
Let me see here. As far as a receipt is concerned of a paper copy or a fax?
Yeah. When they sign, to say that a dated copy signed by the applicable parties listed.
Oh, I'm sorry. Which section are you on right now?
A1.
A1. Notice provided person shall maintain a dated copy signed by. Yeah, I mean, if it's a scanned copy, I don't see why that would be as long as it's signed by them, I don't see that would be a problem.
Okay. And what's the significance of 3 years?
That was the amount of time that was put in the previous regulation package. So I just left it at there. I don't, again, because it's my first meeting with this committee. I'm not quite. I don't know the rationale that was forwarded before as to the 3 years.
No problem. I think you're doing a great job answering for your first day.
Thank you. And I apologize for that, but I can find out the answer for the next meeting.
Just out of curiosity, Eileen, what would be your recommendation or your thought on the 3 years?
Yeah, the 3 years doesn't make sense to me. I think it's too long.
It's too long? Okay.
Yeah, I think so. And then on the, I think there's got to be a way to separate blank or notification for people who are court monitored or situations that are court monitored versus ones that are non-court monitored. That's the way I see it, like panning out, like a little simpler.
Private versus court.
Right. I agree with that.
For instance, if they do receive notice as part of the probate process, then maybe they could be excluded from the additional notice?
Correct.
If they,
Right.
If you don't mind, this is Fred Chan Yu. If you guys don't mind, could you guys put out the reason for maybe separating between a private fiduciary as opposed to a court-ordered or court-appointed fiduciary, just for my information? Thank you.
A court-appointed fiduciary is appointed by the court and under the court's supervision through the whole case. Private, there is no supervision. There is the fiduciary standard that the fiduciary must follow and still must follow the terms of the trust or the POA. So again, no court supervision on private.
And the rationale.
I mean, like,
Yeah. So go ahead.
Private. Okay, so I'm a private fiduciary. I do both court-monitored clients and non-court monitored clients. Yeah. Sorry, this is Eileen. Okay. So when something is court-monitored, everything that you're asking for here is already, in my opinion, being done.
Correct.
It's already, everybody's being notified. So the extra protection, in my opinion, should be for the people who are not court-monitored.
Mm-hmm.
But if
Clients who are not court-monitored.
so, if they're court-monitored, then or court-appointed, then the court rules or the applicable probate statutes require that the fiduciary provides notice to basically whoever is required to receive that notice by law that the licensee is licensed by the state of California?
The fiduciary could not be, this is Dawn, could not be appointed unless their license was current.
Okay.
They have to attest to that in the confidential screening form.
Right.
And everybody,
It's also,
go ahead, Eileen.
this is Eileen, this is also part of the petition indicates that we are licensed by the Professional Fiduciary Bureau.
And in addition, this is Dawn, in addition, a court investigator comes out and interviews the potential conservatee or guardian and also reviews the fiduciary's license, also with APS through the Licensing Bureau, and will determine whether that is a good fit for the client or not.
And those conservatorships are reviewed annually or biannually?
But at the end of the day, they do receive a written notice from the court or whoever.
Before the case even begins, yes, it's in the initial petition.
Okay, all right. Then, if that's the case, then we can revise the language, maybe put an exception on there.
I've got a question. Are the notification lists, are they standard throughout California, or is it maybe different by jurisdiction?
To my knowledge, it's standard. You have a notice of hearing and you have a petition, and in the petition are the relatives who are required to receive notice and/or the VA or certain other agencies. So that is a mandated form.
And then
Thank
prior
you.
to appointment, there is a court hearing, and everybody has a chance either to agree or disagree to that appointment.
Thank you.
Just one last question. So I guess at the beginning of this process, when the notice is part of the petition, right? Would just the client, I'll just in short, the client, they would receive a copy of that notice, right?
That's
Correct.
correct.
And so then
Yeah.
that notice will be there. Okay, all right. And that will be served by the court?
No, it's served by a party who's not a direct party to the case, so it can be a.
Sheriff or?
Right, some
Okay.
other.
And there would be
person.
proof of service?
Oh, yes, absolutely.
Okay.
And this-
It
and this-
cannot move forward without proof of service being filed.
And in addition, when the probate investigator goes out to meet with the client, does advise them of their rights, advise them that they're under a conservatorship. If they choose to protest the conservatorship, all the rights herein apply to the client.
Right.
Yes, I'll definitely take a look at that, and then I guess for the next meeting, we'll just.
I can send you a copy of the petition, the notice of hearing, and kind of what the court investigator does. if that
I would like
help.
that. Thank
Okay.
you.
You're welcome. It is, yeah.
Okay, wow, great. Huh. We learned so much. So any comment from the committee members? Any other comment from the public, any public comment? Jeff?
Hi, Gerry Desmond for PFAC. Wanted to note that over the last year and a half, the draft regulation has progressed and improved. I know that PFAC has provided a number of comments. I hear a number of comments here today. The PFAC is looking at this draft now and would appreciate the chance to provide some comments in a week or two, if that's okay, for consideration. And we do recognize the statutory charter that I think the deadline was almost 19 years ago for a regulation of some sort and the intent of the regulation. And we also note the difficulty and the different circumstances are being addressed in subdivision D. That's been rewritten a number of times, and it's going to get closer with the more work and scrutiny and the work of the advisory committee too. And that's what I think PFAC will be focusing on as well. And we appreciate the chance to get further input before it moves forward, but we look forward to intent, in concept, PFAC supports the idea of there being a regulation that provides for customer notification that the licensed professional fiduciaries are regulated by the Bureau, and here's the contact information. So thank you for the work that everybody's conducting.
Thank you, Cherry. Thank you for, so now we are at item number 12. Rebecca, please start discussion for the agenda item.
Thank you. So I think I've been pretty clear that one of my main goals as the new Bureau Chief is to improve the visibility of the Bureau and the profession. I tried to highlight this during both our Sunset Review hearing and my Senate confirmation. Bureau staff and I have been trying to identify and attend as many outreach events as possible, but we could use help in identifying events from our advisory committee members and the public and stakeholders. As you know, we have pretty limited travel funds, which, presents its own concerns. But if there's events that our staff that we can drive to, that would be easiest and best. I've been trying to join as many listservs as I possibly can. If there's things that I'm missing, I'm just all ears and very eager for your suggestions. I don't know if you have any thoughts today to discuss, or even if it's just in the back of your mind and you think, hey, Rebecca should know about this, shoot me an email. I'd appreciate it greatly. Thank you.
Any comment from the committee? Any comment from the committee members? Any public comment? Thank you, Rebecca. Item number 13. Rebecca, please start discussion for this agenda item.
Thank you. So I have been remiss in publishing a newsletter in quite a while, and I'd really like to publish one at least twice a year. I personally work really well with deadlines, so I would like to have a newsletter ready to go to print by June 15th. So that being said, I just wanted to have a discussion as to what you would like to see in a newsletter, what would be helpful for our licensees and the public. I know we've had a message from the chair, a message from me. There's an Ask Angie segment, which I think is awesome. And I've just, I'm not a fiduciary, so a lot of it's insider baseball. But if there's information that you would like for us to convey, hopefully we can have a little discussion today. Can I get any contributions from people? I have extensive writing and editing experience. I'd be happy to slash and burn any written articles people
Mrs. Dawn,
might
I'll
want to
see if we
submit.
can submit some ideas. How's that?
Awesome, thank
Okay.
you. Thank you, Dawn. And again, even if it's something at a later date that you think of all of a sudden, please just send me an email. Yeah, so June 15th is the deadline in my mind to have it published, so maybe a month before that, so May 15th. Is that doable? And I'll send out emails, not harassing, gently reminding people. Thank you.
Any comment from the committee members? Any public comment? Thank you, Rebecca. So item number 14, Angela, what items have you recorded from our meeting today as future agenda items?
I have 3 of them. The first one was in regards to AB 1779. And I believe, I want to make sure I have this right. I believe, Eileen, you had asked for clarification on whether it was for limited or general conservatorships, correct?
Correct.
Okay. And then the second thing is AB 3144. Rebecca wanted to have a more detailed conversation regarding any changes to that bill and any proposals that may be added to it. And then the third thing I have is for our exam services office to better explain what psychometric the evaluation and how that works. Was there anything I am missing?
This is Rebecca. Clearly, we'll be bringing back the client notification reg.
Yes, of course. These are in addition to what we would add anyways.
Okay.
Yeah, so,
Thank you.
yeah. Anything else that anybody wants to add? Okay, that's all I have then.
So are there any other items the committee member would like to add? Is there any public comment? Thank you, Angela. Item number 15, the following dates are scheduled for the remainder of the calendar year 2018. If you discover after this meeting you do have a conflict, please contact Angela Quata. Wednesday, May 16, 2018, Wednesday, August 15, 2018, Wednesday, November 7, 2018. Okay. Item number 16, is there any public comment on items that are not listed on the agenda? So the meeting will be, is adjourned at 11:29. Thank you.